so I'm going to admit the transcripts of the prior testimony. We'll omit the Exhibit 80 as redacted, and we'll omit State 61. All right. With that, what is the state's situation?
Is a capital punishment abolitionist who began her relationship because Mr. Valerio was on death row. And they said they're going to bring her in here to talk about how they're friends. Apparently, she's friends with a lot of people who are on death row, and certainly her bias is going to be highly relevant to cross-examination. It's something that Lovato says we're entitled to get into. And so I just want some direction from the court, considering the court's ruling saying, don't go near this unless you bring it to my attention. If I'm mistaken, and this is a different case, Stevens, than our research has shown, but I believe, based upon just even what Mr. Vitaro says, that this is the same individual.
All right, so where are you wanting to go?
We'll cross-run her by.
Welcome back to the Law News Network, everybody. I'm Aaron Keller. I'll be with you for the afternoon and into the evening as this case we're covering out of Nevada is expected to go live at 4 o'clock here on the East Coast. That's 1 o'clock Pacific time. It's the John Valerio case, and it's a murder retrial. Michel Bryant is here with me in the studio. Michael, good to see you again.
You too, Aaron.
So, a death penalty retrial, and I know you've been trying to wrap your head around exactly what's going on in this case, just as well as the rest of us. 29 years after the original conviction, 31 years after the original crime, and we've got a jury trying to figure out whether this man should be sent back to death row or possibly if he deserves life with a chance at parole.
You know, it's a case that that the underlying facts are important to determine whether or not the death penalty should be imposed. That's critical. But how much of it do you need to retry to get to that decision? And apparently the judge in this case is like, hey, bring it all in. Let's go. Let's just cover everything. If it's relevant, if it's not, it seems to me the door is wide open for this guy.
One of the interesting things that I found looking at the statutes here was that in Nevada, these death penalty phase hearings don't follow the regular rules of evidence. So hearsay is allowed. And there was a bit of a fight about that earlier on in the case because some of the police officers who were involved in the original investigation testified not only to what they saw or heard, but also a few things that apparently were in the police reports. And the defense was able to corner them on it, but that's allowable in this kind of a hearing.
And what's interesting is at least one of the witnesses has talked about what has happened to Mr. Valerio since being imprisoned. You know, visitors and other
this member of the clergy who apparently has befriended him,
exactly.
become a pen pal, talks to him on the phone, and it's like, that wouldn't be
that is so beyond relevant. I mean, let's face it, we're talking about what a jury decided back in 1988, right? And the law that has been modified since then that the jury probably will not even hear about. But is it relevant how he may or may not have changed since he went into prison? The jury, when they convicted him and found depravity of mind, which is what they needed to find to sentence him to death, what's it matter whether he's come to Jesus or somehow changed? It doesn't matter. So
you know, I was wondering the same thing. So let's say, I mean, what do we do? Do we give everybody on death row another trial to see whether or not they've become a better person behind bars?
Yeah, I mean it's like a do-over. It just makes no sense.
It's certainly different. I'm trying to understand the fundamental fairness in it. I mean,
well, I know we're talking about putting a guy to death, so let's go to the extremes to try and make sure we get it right. If there is a getting it right, if you're against the death penalty, it doesn't matter. You're not going to like this process anyway. But if you believe the death penalty is appropriate in the right situations, then yes, let's give this guy every opportunity to stay alive. I get that. But if you go back and look at the reason this case was overturned, finally, after the second whack at the Ninth Circuit, they went through 2000 and lost a 3-0 decision at the Ninth Circuit. They came back, modifying their claims, and presented the case to an 11-member panel, and it was a 7-4 decision. And the whole thing they've talked about is the jury instruction, which includes the phrase depravity of mind, okay? If you look at that jury instruction, it doesn't list depravity of mind in and of itself as one factor. It's part of a string, and that string includes torture, depravity of mind, or mutilation. It doesn't say and. You don't have to find
Yeah,
torture.
you can
and
have
depravity.
mutilation,
Torture
you
and
can have torture,
If we
or
take
you can have just the mutilation.
If you take depravity of mind out of that jury instruction, would they have not found torture with 45 stab wounds? Would they have not found mutilation with 45 stab wounds, even if it was in some weird eight stabs at a time
I mean,
configuration?
that's the prosecution's big argument, and we listened to the prosecution talk about that late last evening, okay? You know, their big push is saying that these groups of stab wounds, there were 8 here, 8 there, 8 over here, 8 over here, and then 8 over there. 5 groups of 8, and they say that that is some kind of ritualistic torture, because they even got the defense's own medical expert, a trauma surgeon, on the stand to admit that it's just bizarre to find stab wounds in groups of 8 in 5 critical locations on the victim's body. So, you know, that expert, I thought, fell apart for the defense. All they need is that, at least under the original jury instructions.
No doubt about it.
But part of me wonders if there was a problem with the way the original jury instructions were written on the form. Because here's the big issue. If the jury instructions only had a form that said, you know, check this box for death, okay, if there's an issue with the original language, they do have to throw out the original conviction. This, I suspect, is why so many of these jury forms now are so complicated. If they can find for the death penalty on torture or mutilation or depravity of mind, I know depravity of mind fell out, but let's say the original jury form had a checkbox for each of those 3 prongs. Do you find depravity of mind? Check yes or no. Do you find torture? Check yes or no. Do you find mutilation? Check yes or no. If there was an independent box on the original form for torture or mutilation, the court's ruling wouldn't have any teeth, because they would just say, okay, well, you know, so whatever. The jury found the other critical parts of the phrase. The original sentence stands.
Right, and it's always vagueness of an instruction that causes the appellate court's problems. You know, they want to spoon feed these things to the jurors, or at least make sure that it was something a normal person might understand. I don't think this is that tricky. I mean, I'm no genius, but it doesn't seem to me, without the word "and" in between each of these items, it's not a group effort. It's an or proposition. In fact, they use or after depravity of mind or mutilation. Torture, comma, depravity of mind or mutilation. I think the average person understands it doesn't have to be all 3 to get a conviction.
Well, yeah, you're making exactly the argument that the many dissents in the en banc 11-judge panel brought up in the dissenting opinions. They said, hey, look, there's enough evidence on the table to say that the jury probably found mutilation at a minimum, and then maybe torture, depravity of mind. Okay, well, we don't really know, but why are we ripping this verdict up when it seems pretty clear that the jury probably found mutilation at a minimum? And I think that that's a relatively compelling dissent. I think it's a very compelling dissent.
And that's 4 of the 11. It's not just a lone wolf out there, you know, coming up with something. And, you know, I think, you know, I'm a California practicing attorney, and so I'm very familiar with the Ninth Circuit. They're out there. They're out there. They will go to great lengths. They're very liberal. And again, in a death penalty case, I don't have a problem with that. In a case where maybe the crime itself is more in question. I mean, there's nobody doubting the guilt of the defendant in this case.
No, I don't think anybody suggested that at all. You know, I mean, the evidence is pretty convincing. And a lot of times I get bashed and saying somehow I'm in the defense's corner. It's not just that. I just call it the way I see it. You know, we've got cases that we've covered here where I've said, look, I don't think the prosecution's proven its case beyond a reasonable doubt. Well, guess what? In this one they did, and the guilt phase of this sticks. They've got gravel from the defendant's walkway on the front seat of the car in which the victim's body was found. The body is wrapped in the defendant's bed linens.
Blood all over his
blood
place.
in his
He's
in
in
his
the call girl's
bedroom.
book, which is in his pocket. I mean, yeah,
the address book is in
crazy.
his presence. The keys, I believe, her keys were also in his presence. So, okay, you know, no issues with warrants here. They got a warrant to search the house. He tries to run down one of the cops who tried to arrest him. The original jury acquitted him of murder on that. Apparently didn't think that that was enough of an issue because the cop got out of the way. But they also originally tried to charge him with murdering the cop that he tried to run down when the cop was trying to apprehend him. So, you know, it does not seem like there's a lack of evidence against this guy. I know that, yeah, back then they didn't have DNA. Well, guess what? There's enough other evidence here for this to have been a conviction.
With all deference to the Innocence Project and my former colleague Ron Kuby at Court TV, who are still out there doing the good work and fighting the good fight, this is not one of those cases.
No.
This is not one of those wrongful conviction cases. This is all about the language in a jury instruction that, as you pointed out, has since been removed, just for general vagueness overall. The Supreme Court took it out. It actually took an extra 8 years, I think, before the Nevada legislature followed the Supreme Court's removal.
That does bug me. You know, if the Supreme Court says the language is bad,
and they stayed with it for a number of years,
you better pull it out of your instructions, because then look at, they've got not only this case
Everyone's
being
stacked
retried,
up.
but they've got all the other ones stacked up as well. So they've got to go back and retry all of these things, and to what waste of energy, what waste of expense. If the instructions are bad, take them out of your law. You know, don't leave them in and then hope they magically come back. I mean, that just seems strange. So here we are. The original statute, or I should say the statute on the books now, says the jury could consider 4 possible punishments. But the judge is only submitting 3 for reasons that I don't quite understand yet. Maybe they're going all the way back to the original statute to look at the punishment and not the current one. I haven't gone all the way through the legislative history of the statute to see
Why not?
Hey, look,
It's so exciting
I have
to
to
read.
stop my research somewhere. I already went through it. The bottom line is the jury can examine one of the following 3 penalties here. The death penalty, we know that. That's back on the table. Life without parole, or life with the possibility of parole after 20 years. Part of me wonders if all of this testimony about this defendant's behavior in prison is going to come before this jury. Well, it has come before the jury, which in a normal death penalty phase trial, that wouldn't be there, okay? But this jury heard it. Do you think it's possible that some people on that jury might look and say, well, being on death row for 29 years has reformed this person. We'll turn around and give him a shot at parole.
Yeah,
I mean,
obviously,
talk
it's
about
possible,
a massive
but that's-
change in circumstances.
Yes, and something you could never foresee when you wrote the law, when you put it into application, that, hey, 29, 30 years down the road, you kind of get another look. You get a second look, and you get a retroactive application of your penalty, because that's what it would be. You know, we're going to penalize you based on what you've done the last 29 years to correct the original conviction. It's crazy.
I know, it's just, I said yesterday, it's one of the most bizarre things that I've seen in a while, and I always say truth is always, or almost always, stranger than fiction, at least 99% of the time, it seems. You know, talk about a change, though. It could happen, though, because they've just piled up witness after witness after witness talking about his behavior since the original trial. And again, I don't know if there was a ground for the prosecutor to keep it out. I think the prosecutor tried to say, hey, look, I need to argue in front of the jury that none of this is relevant.
Of course.
You need to zone in on that. And I'm waiting for not only the remainder of the jury instructions, but for those closing arguments when they come up on Monday morning. I'm really going to be interested to see how the prosecution does this. Do you want to take a crack at what points you think they ought to hit?
Boy, you know, if we're talking about to try and get the least penalizing penalty, I believe it's totally irrelevant, but if you're trying to play to the audience, the jurors, then you got to focus on he's a changed man. You know, that's his thing. And we now, as the defendants, and I'm going to take the defense side, we get the chance to show you jurors that, you know, the system does work in some ways. This guy has been changed as a result of being incarcerated for so long, and we're here to try to correct a mistake that was made back when he was first convicted. We have a tremendous opportunity now, a rare opportunity, to actually help this man because he has changed so much during the course of his incarceration. And it's just this unusual set of circumstances that brings all of us here, and you, Mr. and Mrs. Juror, have a chance to change this man's life and reward him, in effect, for what he's done once in prison. It's crazy.
Yeah, I think that's probably going to be the defense's tactic. Prosecution's tactic, my guess, is going to be to say, look, stop listening to all of these discussions about exactly how great of a guy he's been since then. First of all, discount the member of the clergy who comes from a denomination that tends to be anti-death penalty. So she has a bias in injecting herself into your, brains because it's part of her doctrinal beliefs. Okay, so get that out of your heads. They're going to have to try to wipe the slate clean of that. The state is. Also, what does it matter what he's been like when he's been sitting there in prison? We got to go all the way back. Assuming that the jury knows the history, maybe they don't know that he's been locked up for 29 years. I don't know how much of that information the jury has.
Boy,
I sort of broke my own train of thought there, but part of me wonders if maybe the jury just thinks that they're there to consider a penalty for a crime that just happens to be old.
That would be.
Well, no, they can't. No, wait a minute. They can't be thinking that because they know that he's been in prison.
Yes.
Because the testimony indicated that he had been.
I think it's impossible for them to go along that garden path that the defense is laying out, which is great guy now, reward him after the fact, without knowing enough about his incarceration to at least process it. We know that they haven't really been clued in a lot on his history prior to that. I mean, this guy had some issues. We know they haven't learned about that. If they can focus on what's happened to him since prison, he's got a shot. But the prosecution's got to do what you said. Just ignore that. That's just smoke and mirrors. That is not relevant for our purposes today. You guys are here to look at what the crime was. Does it fit the necessary requirements to put this man to death?
Yeah, they're going to have to get into an argument about telling that jury. When I say they, I mean the state in this case. The state is going to have to tell the jury to follow the letter of the law. This is what makes someone death penalty eligible. You're here to determine whether those characteristics have been met, and it has because of the torture, potentially mutilation, more likely than not. And look at that and say, okay, well, you heard all his relatives get up on the stand and say, oh, he was a great boy, he was very smart. His mother left the family at a very formidable point in his age, an impressionable point when he was relatively young. Okay, well, the prosecution can flip that around and say that explains the anger and the rage. That's why he killed a prostitute.
Yeah, that's why he mutilated and tortured. Yeah, those were motivations for that kind of aberrant behavior. Doesn't excuse it, though. So I think it's going to be very interesting to see how the prosecution attacks this sort of, after-the-fact rewarding of a defendant that has done something so heinous.
My guess perhaps is that they're going to just zone in and say, this is what happened to the victim. We're here to determine what happened to the victim. And they're going to have to stick to that argument and stick to it very, very closely.
What the defense is trying is like a nullification scenario. They're trying to play on all the sensitivities of a juror that might be thinking, what if this is your dad or your uncle or your father, your husband? Look at what this person's gone through, and now they've become somewhat a better person. Don't you want to reward them for that? Don't you want to just ignore the law and make them better? It's a nullification argument.
It's very, very similar to one. And an interesting point in the Nevada statutes is that basically any evidence can be brought up by the defense, relevant or not, to try to save somebody's life. There's a list that's been on the books since 1977, I think. And it's got all of the mitigating factors. And the last element in the list is a catch-all, just as any other mitigating factor, apart from these other ones. So that's an invitation for the defense to throw everything possible to try to sway the jury to save the defendant's life.
You can't blame them. And it's almost like a sentencing hearing where you have people stacked up to say good and bad things about the defendant before the judge pronounces sentence. It's very similar to that, but it's done a little more formally.
Yes, because they have to. The Supreme Court has said you have to have a bifurcated trial, 2 different phases if the death penalty is sought by the state. One is the guilt phase. In this case, that sticks from the original conviction 29 years ago. The question is the penalty, and that's where we're at. So I want to listen to a little bit more of the hearings that we've been playing back for you. A reminder that live testimony is supposed to pick up in about an hour. In the meantime, Michael and I are going to break this down as best we can to give you a sense of where things are probably going to go through the rest of the day today. Closing arguments and jury instructions are slated for first thing Monday Pacific time, probably around noon here on the East Coast. So that's the timeline in the John Valerio death penalty retrial. We'll be back after this clip.
Is a capital punishment abolitionist who began her relationship because Mr. Valerio was on death row. And they said they're going to bring her in here to talk about how they're friends. Apparently, she's friends with a lot of people who are on death row, and certainly her bias is going to be highly relevant to cross-examination. It's something that Lovato says we're entitled to get into. And so I just want some direction from the court, considering the court's ruling saying, don't go near this unless you bring it to my attention. If I'm mistaken, and this is a different case, Stevens, and our research has shown, but I believe based upon just even what Mr. Pitaro says, that this is the same individual.
All right, so where are you wanting to go?
We'll cross-run our bias.
Okay, well, yeah, I don't necessarily, I mean, I guess, why don't you give me just a thumbnail as what you're planning on doing, and that way I know I'll turn to them and say, what issues do you have with what Mr. Pitaro?
Well, the part that most concerns me is the reason she started the relationship with Mr. Valerio. How is it that you identified Mr. Valerio as a person to have this type of relationship with? Well, because he was one of the people on death row. And I'm unclear right now whether or not she found him from the websites that are out there for death row inmates to find abolitionists. But my main concern is that whichever way I think of this in my mind of going about, you know, you're an abolitionist, you don't believe in this, you reached out, you started the relationship with Mr. Valerio, and how is it you found Mr. Valerio? The answer every time leads me back to, I can't think of a way to get there where I get to bring out that this is a manufactured relationship, manufactured around the fact that he's a death row inmate. I don't know how it is I can bring out that situation and her biases in coming in here to say, oh, he's a lovely individual. Yeah, you think about that about every murderer that's on death row. And I don't know, everywhere I turn, I get to the point where it's going to come out.
The issue is referencing to death row.
Correct, that's the issue for me, is that the court told me not to go there. We were able to limit it for Hatcher, we were able there to limit it, but I just don't know how the answer is going to come out. Unless I'm wrong and there's some other reason that they have this relationship, but based upon my research, it's my belief that their relationship started because Mr. Valerio was on death row and that she routinely
Can we
befriended
say that
people.
he was that she has this relationship with people who are death penalty eligible?
Why can't you just say, like, the anomaly these things are, is that she's involved in, well, you don't have to use the word prison ministry, but you can...
You know, being a death row abolitionist is
I don't know what
different than
death row
prison
abolitionist is.
Is
what? I mean, how does that reflect?
I mean, anti-death penalty, I mean, someone who goes to the nth degree to try to defeat the death penalty for anyone.
Well,
I'm not saying that that's bad or wrong, but I mean, it goes to her perspective.
No,
and
being a
her
pen
relation.
pal and what she's going to testify to, any more than the juror who is opposed to it. I mean, I just don't see how the fact that someone is opposed to the death penalty goes to the fact she's going to testify the relationships she had with him through being...
But I mean, if she has relationships with 20 or 30 death row people, and she does this in an effort to enhance their chances of escaping death row, that definitely goes to her bias.
Well, I don't think there is, Tom knows, he's the one that has dealt with it, but to say that she's going to come in here, she's an ordained Presbyterian minister, she's going to come in here and she's going to commit perjury in this court so she can try to get someone off death.
Well, wait, you know, they're entitled to attack her bias. And just because she is a Presbyterian minister doesn't mean that she doesn't have biases. I'm not suggesting she's going to lie, but she has biases that may color her testimony and her perceptions. You know, So, I mean, you know, just because she's a Presbyterian minister, it doesn't have any real, those are all points that you can bring out in terms of enhancing her credibility or minimizing her bias, but it still goes to bias and it's still relevant. Bias is bias. And if she hates the death penalty and goes around the country befriending death row inmates in order to attempt to figure out ways to keep them off death row,
Well, it's that last-
I'm not saying that it's not a redeeming quality. I'm saying, though, it definitely goes to her bias.
No, but it's the last part that is the jump.
Well, I don't know, I mean, you know, if, I don't know why she does this. She's showing up at a bunch of different trials of people. I mean, I don't know when she befriends it. If she befriends people who are, you know, getting a shot at retrial, or, you know, she participates in petitions to the court, you know, asking for lien. I mean, again, I'm not saying any of this is not redeeming or valuable depending upon your perspective. There's a lot of perspectives on it, but it definitely goes to bias. And I just don't know what we're talking about. Mr. Erickson, can you give me a sense?
Your Honor, I have had a number of conversations with her. I met with her in person. This is the first that I've heard of her possibly being involved in multiple death penalty related cases. I do know that she, you know, reached out. I believe that she reached out to Johnny through some type of pen pal organization, and has maintained a relationship with him for, I think, going on 10 years.
Since 2009.
Yeah, and that she's been out here, I think, 4 times, paid her own money to come out and visit him, and things of that nature. I will be meeting with her tonight, and I certainly will be looking into this issue. I don't know if the state has information that she has been involved in testified in other cases in Nevada. I don't have that information.
I'm hoping to get some transcripts without telling them what the cross-examination is going to be, but it's even farther than that. Let's just say you are somebody who reaches out to capital defendants, and then you befriend them. Are you someone who is more likely to find a redeeming quality than somebody who is horrified by the actions of this person and would never befriend them? She affirmatively takes it upon herself to locate capital defendants and befriends them, and then she's going to come to a courtroom and say redeeming qualities about that particular individual. I am allowed to cross-examine on it isn't like
I'm not debating that issue. I agree with you completely. The issue is how, and I tend to, at this point in time, you know, say that she has an interest in, you know, helping those individuals who are death penalty eligible, rather than saying that, because at the time,
and that's fine. In 09, that's true.
You
In
know,
09, he's not a capital
yeah,
defendant.
he's not a capital offense, so he's death penalty. I mean, that's not going to shock the jury. Obviously, he's death penalty eligible because we're sitting here for the last 2 weeks doing a death penalty trial. So, I mean, I'm leaning toward, you know, you discussing with her and making sure she doesn't go to death row inmates, and I'm leaning toward, you know, making you all refer to him as death penalty eligible, and that she has an interest in that. I mean, you may ask her, don't you have an interest in helping those people who are death penalty eligible? And she says, no, this is the first guy I've ever, you know, befriended. You know, well, that we aren't, you know, you can ask, did you befriend him because he's death penalty eligible? I mean, she says, no, I mean, I sort of piqued my interest, but because he's a great guy. I don't know what she's going to say. You know, to the degree, Mr. Erickson, you think there may be any issue, we can, you know, try to do something outside the presence of the jury.
Right.
But I'm leaning towards saying, you know, letting the state say, you know, is any of your interest in him because he was death penalty eligible?
That's fine. I mean, that would solve the problem, although maybe the first guy she joined that was death penalty eligible. Certainly the court's not ruling out, there was a suggestion here that if she were to deny my question, I couldn't prove this up through extrinsic evidence because it goes directly to the
Yeah, I mean,
bias.
you can obviously prove bias through extrinsic evidence, but I mean, let's wait until we have that issue. Be sure you've got the right I don't know, whatever, I forget.
There's not that many of them. I believe I do.
Right.
Certainly, if there's any reason for me to doubt there is, and I won't ask her the question, but I can't imagine that this happened any other way.
All right.
We're reaching out to Mr. Valerio.
I've seen a lot of bizarre things in my life, so I'll just leave it at that. But no, I'm leaning at this point in time. I think it is relevant to bias. I'm not suggesting that indicates she's going to lie in any way or commit perjury, but it's relevant to how she may perceive or how she may describe certain aspects of her relationship with the defendant. And so I'm at this point, saying, let's have it, to the degree that she talks about it's relevant, or she talks about her interest in those people who are on death row. Let's just leave it as those people who are death penalty eligible. I mean, even those people who are on death row are just death penalty eligible. They haven't gone.
Welcome back, everybody. That was an evidentiary hearing. Ultimately, it turned into a bit of a show of proof hearing in the John Valerio murder retrial. This is a retrial of the penalty phase of that case. The defendant is still considered guilty as a matter of law. This jury just has to figure out whether he should remain on death row, face life in prison without the possibility of parole, or whether he should be paroled at some point. So talk about a twist of fate for this particular defendant, all because the Ninth Circuit Court of Appeals overturned his original conviction. Michel Bryant is still here along with me, and we just heard a pretty complex evidence discussion about whether or not this friend of the defendant's, who's a pen pal, who started writing to him behind prison walls, should be allowed to testify and what the parameters of her testimony should be. This gets into what we were talking about before about the state wanting to restrict the ability of this defendant to put all of these witnesses on the stand who basically have met him since the original conviction, because it just causes a logical conundrum. I mean, why not retry everybody on death row, as I said before?
And talk about how much they've improved since the crime was committed. What they focused on with this witness that we're going to see coming up here is the fact she seems to be a bit of a crusader. Like, she finds cases like the
a hard thing that many people wouldn't be able to do. I'm not doubting that. My issue with it is just that she wasn't there for the original case, so why are we bringing her here in on the back end? And apparently in Nevada the law allows that. So let's listen to some of the testimony of this woman who befriended the defendant while he was on death row. She talks about her background. She's got a Harvard divinity degree, lives in Massachusetts, and let her take it from here.
Okay, so is it accurate to say that your first contact with Mr. Valerio was through writing in 2009?
Yes.
Okay. And I want to back up a little bit before I ask more specific questions about your involvement with Mr. Valerio. What is your educational background?
Let's see. I graduated from college in 1969, and then in 1982 I went to seminary and got a master's in divinity degree.
Okay. And where did you obtain your master's in divinity?
Harvard College.
And have you worked in an ecclesiastical capacity?
I've worked at 4 different churches. I just retired in June from 12 and a half years at my last church.
Okay. Now, with this pen pal relationship that you have had with Mr. Valerio, was that done in a religious or ecclesiastical capacity?
No.
Okay.
No, it was just, I learned this from my friend, and I thought I just liked the idea of doing it, so I began writing just on my own.
Okay. So I would like for you to describe to the jury the contact that you've had with Mr. Valerio since you met through writing in 2009.
Let's see, Johnny's a better communicator than I am. He writes a little more often than I do, but I think probably we each write about once a month to each other, and I think we did that for about 3 years. And I think at that point, I don't know the exact date, but I have family on the West Coast, and I made a decision to stop by the prison in Ely, Nevada to visit him. So then instead of just being a name and words on a page, we actually saw each other. You can have face-to-face visits there, so I got to know him a little bit. And since that time, we continue to write, and he calls me occasionally, and I have visited 3 other times. So I've actually had 4 face-to-face visits with him, as well as the ongoing letters. So he's become a good friend.
And when you say friend, you are married, correct?
I am.
And you live with your husband in
I do.
Massachusetts.
I do.
And he is aware that you have developed this pen pal inmate relationship with Mr. Valerio.
Yes, of course.
And approximately how many times have you made the trip from Massachusetts out to Nevada to visit John in person?
4 times.
And when you've done that, who has covered the costs for your travel?
Me.
Describe for the jury your interactions with John as far as on a personal level of how you experience him in the 8 years that you've been involved in his life.
I think the reason that we've kept writing and I've gone to see him is because we have an easy flow of conversation back and forth. That he's been an easy person to get to know, and he's thoughtful, and he asks about my life. He's gotten to know my husband. He's talked to him a number of times on the phone, and he asks about him. He asks about my life. He asks about my church. So it has really felt like a 2-way friendship, which I think when I started, I don't know what I thought when I started writing someone, but I didn't know that actually we could become friends and that I would care about him, which I do.
When you describe for the jury, when you come out to Nevada for these visits, how they're set up at the prison as far as your interaction at the facility with them?
And at the Ely prison, it was like 2 days in a row you could visit, so I would go on one, I would arrive and I'd get to have like a 6-hour visit one day and a 6-hour visit the next day, and I would just stay in a motel and then go home, because then you can't visit after that time. So we get to, I don't know. Anyways, we could do face-to-face visits, which means we sit across from each other and there's a table and we tell each other about our lives. I guess we have an amazing ability to just talk, and we've spent many hours talking about our lives with each other.
During these visits, are there other inmates in the area interacting with their family or friends?
Yeah, of course. There's the guards, and then there's the tables with the people. And you're sitting across from the person, and you're blocked off from them. You're pretty close. You're face to face.
Okay, and it's in an open room, correct?
Yeah.
What are some of the qualities that you have come to recognize in John Valerio?
I find John kind, thoughtful, person who's concerned with others. He's always been concerned with my life and the life of the people. Because I was a minister, you know, I would tell him about Mimi or someone who was ill, and sometimes he would send letters to them. He's very thoughtful. That's what I have found, a person who is kind, thoughtful, loving, and not self-centered. I find him helpful to other people. I felt like in the prison he would talk about other people that were having a hard time and how he could help them out. He made the most of his time trying to help other people.
When was the last time that you were able to do a visit while Mr. Valerios was in custody?
Just a few months ago, right after I retired, I came out here and visited. At that point, he was at High Desert Prison. And actually, that was not face-to-face, it was through glass with a telephone. So the other ones were face-to-face. I don't know if you call it face-to-face when you look through glass, but we were close, but we've got the glass and we've got 2 phones.
Ma'am, thank you very much. I have no further questions.
Thank you.
Cross-examination.
That was testimony from KATHRYN Stevens, who has befriended the defendant behind bars, and that was the entirety of her direct examination by defense lawyers. So, Michael, I know you watched a little bit of this last night. What are your impressions watching it again now?
Sweet lady, and Aaron, it drives me crazy, this whole process, that after the fact you can have somebody like this testify that it can have nothing but a favorable effect on the jurors. They have to look at her and say, boy, you know, she's a sweet lady, has no reason to be lying to us about her interaction with the convict, not the defendant, the convict, and you know, maybe he's not such a bad guy. I just think it's so wrong, but you know, the Nevada legislature didn't call me up and ask, you know, should we change the rules about the evidence in a death penalty case?
Maybe you should call them up.
Maybe,
maybe I'll call them up, but look, one of the 2 of us will have to call them up, because, you know, I think that the public policy is that any defendant at any time should be able to present any evidence possible to save his or her life if the possibility of the death penalty can be exacted.
And this is the absurdity of taking that to its logical extreme. It's absurd.
Well, they have to retry him now, so apparently, okay, you know, this is the way it rolled out. You know, what's the prosecution going to do about it? Is the Attorney General going to lobby the legislature to turn around and say, no, it shouldn't be done this way?
No, they've got to play with the rules they've been given. There's no doubt they're handcuffed by this. They've got to hope that they can get through to the jurors and make them understand this is all nice. But let's focus. Let's focus here, folks. Let's look at the crime. Let's look at the defendant then, the convict now. Let's look at what he did. Okay? Great if he's somehow gotten better while in prison. I don't care. And you shouldn't care, Mr. and Ms. Jury member.
Now, let's listen to some of the cross-examination of this particular witness by the state. We heard a few moments ago the evidentiary hearing, which ultimately turned into an offer of proof, where the proponent of this witness, the defense attorney, said this is what she's going to testify about, and then there was a big discussion about how far the state would be able to go in cross-examining her. One of the rules of evidence is that a witness can be cross-examined about bias. That is permissible, and that's how the state chose.
I apologize, I didn't catch, you said that you worked at 4 different churches?
I did.
Okay. Could you tell me about those churches, please?
2 were in Boston. One was, one was the city of Boston. One was Chelsea, which is just outside of Boston. Then we moved to a farm out in the western part of Massachusetts, which is a very rural area. So I live on a farm, and I've served 2 rural churches out there.
What denominations?
United Church of Christ.
And does that fall into, would it be a Methodist, Presbyterian, does it fall into a category?
It's its own denomination. It was, in New England, they were usually called congregational churches, but they combined with some other churches, and in 1957 became the United Church of Christ, which is its own denomination.
And does that denomination have an official position on the death penalty? Will they oppose it or not?
I couldn't I'm not positive. I'm guessing the United Church of Christ is a fairly progressive denomination, so my guess is at different times they've taken votes and probably made some statements against the death penalty. I don't know if they were blanket statements or maybe it was about for youth, or I'm not positive.
Okay, not positive, but I guess you're saying you instinctually kind of feel it would lean against the death penalty.
Would I or the denomination?
Well, first we'll do the denomination, and we'll do you, if that's okay.
You know, let's see, it's a tricky answer. I think maybe the denomination would lean towards against the death penalty, but it's a congregational polity, which means government, which means whatever the vote is on a national level, it doesn't necessarily influence the people in the pews. So you can find people all across the spectrum in any one congregation and throughout the whole denomination. So
Sure.
it's mixed.
And different religions have positions, and members within that religion could take a position different from the church's official.
Of course, yeah, and that's not true in all denominations, but it is true in ours.
And your personal feelings as far as whether you're for or against the death penalty?
Honestly, as a minister, as a believer in Jesus Christ, who I feel like was nonviolent and spoke about loving enemy, it's like I can never speak positively about the death penalty.
And then you come in here today and you testified about your relationship with Mr. Valerio and the interactions that you've had via pen pal interaction and also personal interaction,
Yeah.
correct? And then you characterized them based on your experience as kind, thoughtful, concerned with others, loving, not self-centered, and helpful to other people, correct?
Yes.
And then, I mean this respectfully, do you know the facts of the underlying charge that put him in prison?
Partially,
Partially.
yeah.
Would you agree with me that those characterizations that you're giving probably wouldn't best describe the acts that got him?
Right, I don't know if that, I don't know his relationship with the crime, honestly, but the little I know, the crime is something that was done by someone who feels very different than the person that I know.
Fair to say from what you just said that you don't know a lot about the crime or the facts of the crime?
I don't know a whole lot. It's not something that John and I talk about, and I don't ask. I feel like that's not exactly my place. I am trying to know him now. I have a relationship now.
Totally understand, and that's what I was trying to gather, is
Yeah.
whether you, in your relationship that you created, you know those facts or you don't, and it seems that basically you don't, and it's not something you're choosing to get involved in as far as finding.
Basically, yes. That's
Thank you
true.
very much.
Yeah, thank you.
Is that right?
Yes, yes.
And you've obviously interacted with a lot of people over the years and your work in the ministry and things of that nature. Have you seen people change?
I've seen people change that have gone to jail. I've also seen people change whose lives were completely messed up because of addiction issues or criminal issues or lots of things. I do feel like we're all able to change.
Thank you very
I
much.
have to believe in that.
Thank you very much. No further questions.
That's testimony of a minister in Massachusetts who befriended the defendant, John Valerio, while he was on death row and who was allowed to testify in his death penalty retrial. Now, I had a chance to do a little bit of background research here, and since we listened to that cross-examination about the position of her denomination, let's look at what the denomination itself says. I'm on its website. The United Church of Christ historically has opposed capital punishment, formalized the position in 1969, and have reaffirmed it many times since. Additional resolutions are discussed, and this is an interesting one. The overarching denomination on its website actually lists specific defendants and encourages members to call and urge elected officials to grant clemency to death row inmates. And there's apparently a ministry within the UCC that specifically handles this as an issue. Now, if that's the case, first question for you, Michael, is should the state have been prepared to lay these positions down in front of this witness and really go to town on this issue, or do you think that they went as far as they should have?
I think they definitely should have gone further. She's like a professional witness, you know, an expert who knows how to kind of waffle. Because when asked directly about her affiliation with the church and what their position might be, well, I don't know. They might have a broad statement of. She knows, of course, she knows. And if they
this isn't a broad statement. This is a formalized position
Yes.
dating back to 1969. It's the first or the second sentence on the death penalty section of the UCC's
and counselor,
website.
that would have been the follow-up. Well, isn't it true? And you just read it. Isn't this is you? This is your mindset.
What's she going to say? I don't know. Maybe.
Well,
I don't
she's going to
know.
have to say, oh, I guess, but I'm not really that deeply involved. I mean, she's a good witness, so she's probably going to waffle a little bit more. But from the prosecution standpoint, they're exposing her bias, and that's critical.
Yeah, I mean, this just adds another wrinkle to this testimony. And again, I mean, neither you nor I, from what I've gathered from our off-camera conversations, are complaining about her position at all. People are allowed to have that position, and at no point have I ever expressed here whether I think the death penalty is a good thing or a bad thing. You know, we're just analyzing the issue from a legal perspective here. And it kind of goes back to this whole relevance thing. Is it relevant what her impression of this defendant is this many years after the original crime?
And as
not,
she just
not
admitted-
everybody on death row gets the chance to have a second
No, you
trial after they've been incarcerated for 29 years to get all of their, you know, additional friends to testify on their behalf.
Yeah, I mean, this is taking the you know, the second bite of the apple to the extreme. And she admitted in her cross-exam that she didn't know much about the underlying facts of the case, and you know, that's not what she and John talk about. It's more about him now. Yeah, every time she says something like that, she's making my point, and it sounds like your point to some degree, that why are you there? You know, you had nothing to do with what happened before. You know very little about it, if we believe that statement. Then what do you got? What do you got for us? How are you helping this jury get where they need to get?
Well, other than to try to inject yet another mitigating factor into things, because the way the jury's got to deal with this, and we got a sneak peek of this if you stayed up and listened to some of the arguments about the jury instructions with us last night in the 8 o'clock hour here at the LawNewz Network. The jury's got to take the facts and say, okay, what are the aggravating factors, and then basically sort of come up with a mental or maybe even a physical checklist, and then say, are there mitigating factors that would absolve the aggravating factors? And then they're supposed to rationalize that out into some kind of a decision. So, I mean, is it possible if they turn around and say, well, you know, there was mutilation and there might have been torture, but we don't really know, and we don't know really if there was a lot of, you know, other stuff going on. I don't know what they proved in the original case. They must have been able to prove premeditation. I'm assuming that's part of first-degree murder in Nevada. But are they going to just take that and say, okay, well, we think this is what happened to the victim. Oh, but, well, you know, his father loves him, and his stepmom loves him, and then just say, well, that, you know, and the minister says he's a great friend, and say, well, that mitigates it, so we'll just walk away.
You know, this is tantamount to having a sentencing hearing where everybody stacks up to talk about the defendant before sentencing and says, you know, 15, 20 years from now, this person's going to be a much better person. I know it. You know, he's going to undergo certain changes. We need to give him credit now, at the time of sentencing, for what he's going to be 15 or 20 years down the road. That's what's happening.
And that would be absurd. You know, that never
Of course.
happens.
Of course.
Yeah, I'm a bit surprised at the way that this is played out. I'm going to have to reach out to some of my contacts in Nevada and ask about this situation. So here's the thing. We're going to listen to the redirect of this witness. It's short, it's a little bit less than a minute, but this ultimately is all of her testimony. She was on the stand for a little bit more than 8 minutes on direct. It was a little bit less than 4 minutes, I think, on cross, and then she had this extra minute. Let's listen to that now.
You've obviously interacted with a lot of people over the years, and you work in the ministry and things of that nature. Have you seen people change?
I've seen people change that have gone to jail. I've also seen people change whose lives were completely messed up because of addiction issues or criminal issues or lots of things. I do feel like we're all able to change.
Thank you very
I
much.
have to believe in that.
Thank you very much. No further questions.
Any recross?
No.
Does any member of the jury have a question for this witness? If you do, write on a clean sheet of paper with your juror number and raise your hand. Not see any hands this time. Anybody? All right, thank you very much, ma'am, for your testimony. You're excused.
Got a little bit more of substance there. Some discussions about people being able to change. She believes people can change. She does admit that she knows that he was in for first-degree murder, but apparently she doesn't care very much about the details.
And what I think is interesting is they did not get into the fact that she seems to be a professional crusader. That John Valerio was just one of many. The judge obviously ruled that was going to be irrelevant. I don't know why he would care at this point. Everything else seems to come in, but they didn't get to talk about it. So it does make it sound more like this was a special case for her, when in fact we know it wasn't. It was one of many cases.
It was. I think I'm going to dial back a little bit further and go to clip 31 here. This is the defendant's father on the stand. He's a little bit hard to hear. He's in his late 70s and traveled some distance, I believe, to attend the hearing. But this is the defendant's father taking the stand to try to save his son's life.
Please tell the jury how you are related to Johnny Valerio.
He's my son, John.
Mr. Valerio, how old are you now?
76.
And where do you currently live?
I live in Las Lunas, New Mexico.
And how long have you lived in New Mexico?
I've lived there about 30 years.
And I'm sorry, did you say 30 years? And, Mr. Valerio, are you retired now?
Yes, I am.
What type of work generally did you do before you retired?
I was field equipment operator at the Animax mines, copper mines.
Okay. Was there a time that you were married to Johnny's biological mother?
Yes,
And approximately how long were you and she married?
10 years.
And did there come a time when you and she divorced?
Yes,
Approximately how old was Johnny at the time of the divorce?
it was around 17, I think. 17.
Okay. And I know that we're talking a long time ago. And did you then take on the responsibility of raising Johnny and his sister Jewel?
Right.
Okay. And I want you to think back as best you can how young the children were when it was that the mother left, if they were younger than Johnny being 17.
Yes, I do.
Okay. You remember that he was approximately 7 years old when you had the divorce with his mother?
About that, yes.
Okay. And I'm not trying to put words in your mouth.
No, that's okay.
Was Johnny a young boy at the time of the divorce?
He was.
After the divorce, how much interaction did Johnny's natural mother have in Johnny's life?
Not very much. We didn't see her very much.
Okay. And after the divorce, did she continue to live in the same town that you were living in?
Yes.
How did Johnny react to his mother leaving the family?
We shook up about it. Yeah, I missed her.
And were you able to to tell that as his father, that it was hard on him?
Yes.
During the time that you took over the responsibility as a single father, raising Jewel and Johnny, were you working full-time during that time period?
Yes, I was. It was shift work.
Okay, and when you say shift work, describe for the jury what you mean by that.
Day, afternoon, midnight, graveyard.
Okay, so that means that your shift would rotate between
Yes.
different times of the day that you would be
Right.
working. During the times when you were working and the children were young, who was it that would stay with Jewel and Johnny?
We had a lady named June and Algie lived right across our street. We lived in a trailer park. And I asked her if she'd take care of him or watch over him, you know, just check on him because I had my trailer right straight across when I was at work. And she said she would. She worked there for a long time until they passed away.
Okay. So you had a neighbor across the street who would help keep an eye on the children when you were
Right.
working? Describe for the jury the types of things that you and Johnny did when he was a child.
Okay. A lot of fishing, some hunting. We had to go up to Wyoming to hunt with my brother. And right at home there, we used to take the whole family and go. Our neighbor and his daughter and my daughter and June, we'd go fishing. You know, a couple of days. Go home and go about our business.
When Johnny was in high school, did he participate in school sports?
Yes, he participated in basketball, football. He was pretty good at sports.
And when your work schedule allowed, did you try to go to his sporting events and support him?
Well, sometimes I could and sometimes I could not. I'd be working, see.
Okay. But on times where you didn't have a work conflict, did you try
Yes,
to go
sir.
to his sporting games?
Yes.
Sir, is it accurate to say that you and Johnny had a close relationship? when
Yeah,
he
we
was
did. We sure did.
And how would you describe to the jury the type of young man Johnny was up until he was 18 years?
See, you know, our kids are pretty good. My kids, fair, good.
Uh-huh. But from your perspective as his father, did it appear to you that he was struggling with the departure of his mother in his life?
Well, I think so. I affected him.
Now, obviously, Johnny has been in prison for many years now.
Yeah.
Over 30 years.
Wow.
Tell the jury what type of contact you have been able to maintain with Johnny since he was put in prison.
Well, being that we live so far away, we made it a plan to come every year if we could, to visit him at the prison. And stay with him, visit him, and take off back home.
Okay, so you and your wife Judith, you travel from New Mexico approximately once a year to have physical contact with Johnny, correct?
That's right.
Do you also maintain contact with him through writing letters during the year?
Yes, we do. He calls us and we communicate through letters.
Okay, so both phone calls and letters throughout the year, is that right?
Yes.
And how would you describe your current relationship with Johnny?
Good, fair, I guess, good.
Okay. is it accurate to say that you get out as much as you're allowed with your health and the restrictions of travel to come see him?
Yeah, sometimes it's pretty heavy, but make it.
Okay. How has your relationship in the last 10 years or so been overall with John?
Not too good. Very good.
Okay. Thank you very much, sir. I have no further questions at this time.
All right, any cross-examination?
No, thank you, Your Honor.
Does any member of the jury have a question for this witness? Not seeing any hands. All right, thank you very much for your testimony here today, sir. You're excused. Do you need any help, Marshal? We might you.
That was the father of defendant John Valerio testifying at his death penalty retrial. And we did get some biographical information about the defendant's family out of not only the father, but some of the other witnesses who testified. We also heard in that clip that the state chose not to cross-examine this witness, and that seems like a wise decision. My trial advocacy professor's words are echoing in my ears, and she said, you know, a lot of attorneys have the urge to jump in there and ask questions just to say something, but if it's really not going to get you anywhere, don't bother. And I think that those words are wise words, Michael.
Oh yes, the hands in pocket approach. So you just go, no questions, Judge. Yeah, and this witness at least getting closer to something relevant and talking about the upbringing of his son. He was his dad was effectively a single parent because mom was nowhere to be found, which may have been a good thing. From what I'm hearing, she was not the nicest mommy.
That's what the other witnesses had testified to. Apparently, she was pretty harsh on the defendant. You know, and part of me wonders, is that the defense's attempt here to try to say that this is an excuse for his behavior? Is it a mitigating factor if he had a horrible relationship with his mother?
Yeah, and at least, again, now at least we're talking about things that led up to the crime itself. Those things are far more relevant than, hey, he's a great guy now. So I have no problem. I mean, Dad's struggling. He's mid-70s. His health is poor. Not a real, you know, he's just a regular guy. So he's not there, pontificating to the jury. He's just speaking his mind. And when he describes the relationship with his son, it's fair to good. I'm not sure what that means. It's not a glowing recommendation, you know, of his son, but that's how he describes it. Back then, fair to good. Now it's fair to good.
I mean, how does this line up in your mind as to the mitigating factors? You do at least think that this is more relevant than what we heard out of the minister.
Oh yeah, yeah, and I think it's helpful. The kid didn't have the perfect upbringing, and we know how those things can spiral into, emotional problems, behavioral problems. So at least you're chipping away at the iceberg. You're not getting very deep, but at least you're getting a sense that the convicted felon had a rough go as a kid. Is that an excuse? Is that going to give the jury enough to say, well, let's not kill him, let's just put him away for life, or what the heck, let's let him out? I don't know. It's not a lot.
There's been a lot of discussion about how the times have changed in the last 29 years. You think 29 years ago they would have just looked and said, whatever, you had a tough childhood, so did half the rest.
We all have a tough childhood. Yeah, we all walked to school in the snow.
Uphill, both ways. Yes. I knew where you were going to go with that, and I was saying the same thing that you were thinking. So, 29 years ago, would they dismiss that, and then today, in what's arguably a more sensitive culture, would people look at that and say, well, that's a mitigating factor, we should spare his life?
Yeah, it wasn't as warm and fuzzy back then, and I don't know how it plays today. I don't think it was strong enough in any decade to make a huge difference. Whether you grew up when John Valerio did and you can relate to having a single parent, or whether you're looking at it now saying, yeah, single parent, we know that's tough, but we haven't heard enough to really mitigate what he did.
We're going to listen to a little bit more testimony from family members because we're expecting the trial to start back up here live in about 10 minutes. A couple of interesting procedural things had to happen in this case because not all of the witnesses who were present for the original trial 29 years ago on a crime that happened 31 years ago are available for the current case. So what happens then? Well, under the rules of evidence, if a witness is unavailable for one of a list of different reasons, then any testimony of that witness at a previous hearing or court event that was done under oath and that was done where both sides had the chance to examine and cross-examine that particular witness, then it can be read into the new hearing. And that's exactly what happened here more than once. I think I'm counting 3 or 4 times off the top of my head where someone actually got up and sat on the witness stand and just read from the transcript of the original hearing. Sort of interesting that they had actors kind of go in, or I shouldn't say actors or actresses, I should say surrogates, actually go sit on the witness stand and read this back and forth to try to simulate a live question and answer session, because I've seen this done a couple of different ways and it can be done one of a number of ways, but presumably this helps the jury at least understand the flow of it a little bit better, even though it's really clear that the person doing the reading on the witness stand is not acting out the part in full. So this is testimony of Ben Valerio, who is the defendant's uncle. It's being read by someone named Dustin Marcello.
Here's the age there, so it had to have been 8 years ago or so.
Okay, now when you say Johnny, is that John Valerio who is in a courtroom here?
That's correct.
So about how old would he have been at that time?
7 years ago, made him about 15 years of age.
So he was older than the other children in this picture.
That's correct.
How did he get along with your kids?
Very well, they really liked Johnny.
How much contact have you had with John through the years when he was growing up?
Well, for the first 7 years, it was a steady relationship. He lived in the same town. His father and mother lived in the same town I did in Provo, Utah.
What kind of kid was he?
Very well-mannered youngster. How do you describe a youngster? He was, not unusually different than most kids.
Typical kid?
Yes.
After you moved away or he moved away?
Yes. He moved to Tucson, Arizona at about the age of 7 years of age, I believe. And the times that we did get together were vacations and whatnot. His father and his sister and himself coming up on vacation, or us down in Tucson for Easter or Thanksgiving, or whatnot on vacations as well.
About how often would you see John?
Oh, probably once a year.
How did he act at those family functions?
Very well. We played football together, nothing out of the ordinary.
When was the last time that you spent any time with John?
Approximately 4 years ago. He came up to Evanston, Wyoming, and we spent 4 days with our family. At least 4 or 5 days with our family in Evanston.
What did you do at that time? What did he do with you?
He helped me with my chores around the house as far as the wood cutting and whatnot. Sort of a family tradition. We'd go up and get wood and whatnot, and he helped with the chores around the household. He also helped with my pickup. I was having problems with it, with the transmission, and he helped me with that. We had a little time to do some hunting, and he participated in the family functions of the evening. Seemed like he enjoyed that setting very much. The dinners and the snacks in the evening, and we had evening prayer, and he participated in our prayers. And so it was a very good time for us while he spent the days that he did with us in Evanston.
Did he tell you where he would be going after he left your home at that time?
He was going to his grandmother's in Provo, Utah.
Would that be your parents, your mother?
Yes.
What are your parents' names?
Jose Valerio and Marie C. Valerio.
Are they still living?
Yes, they are.
Where do they live now?
In Provo, Utah.
I'm showing you what's been marked as defendant's exhibit. Can you tell us what this picture depicts?
Yes. It's of my father and John, his father, and my mother and Johnny.
Yes, I'm showing defendant's exhibit D.
Okay, good. Yes, it's my father and John, his father, and my mother and John.
Can you tell approximately when that picture was taken?
Oh, he appears to probably be around 16, 17 years of age there. So it would have been 6 years ago, 5 or 6 years ago, I imagine.
When was the last time you spoke with your mother?
Last night,
Was she aware that this hearing was going on today?
yes.
Did she indicate a willingness to be at this hearing?
She wanted to be here very much.
And why isn't she here?
She's in poor health, and also my father.
Also, your father is in poor health?
That's correct.
Mr. Valerio, are there any reasons that you know of why this jury here should spare your nephew's life?
Well, from what I've gathered in the short period of time, is merely that there's so much circumstantial evidence, for one.
Okay, but they found him guilty, as I explained to you. I understand what you're saying, but the jury has made its decision, and we have to abide by that. Is there anything about John that you think he could do with the rest of his life, if he's allowed to live it out, that makes you...
Well, providing that he can have parole at one time in his life, I'm sure that Johnny himself would be an asset to the community if given the chance.
In what ways?
Well, I'm not certain of all the programs that they have in a prison facility to where he could better train himself for the outside world in a sense. But I'm sure that given the chance, he could handle that very well.
Is he smart?
Oh yes, there's no doubt in my mind that, he's not lacking in intelligence. I don't believe at all.
Is he a hard worker?
Yes, he is. When there's chores to be given to Johnny, he abides by them. I haven't had problems with Johnny in that matter.
Thank you. I have no further questions.
Is there any cross-examination?
No questions.
All right. Okay, thank you very much.
Thank you, Your Honor. We're actually going to have...
So that was testimony from the original case being read into the current case by someone who is sitting in on the witness stand as a surrogate. The family photos were put up on the screen for the jury to see, but earlier on and later on, you actually saw the witness handling the photos. And Michael, I think from a procedural standpoint, that's probably the best they could do.
I really
this
like
is
it,
way
yeah.
better than the standard monotonous readback.
Oh, yeah, yeah.
Stuff. Yes, John is a nice
It's brutal.
boy. You know,
Sometimes
it's
the
not that
clerk
kind
reading
of stuff.
both sides just to get it in the record. It's brutal. This is, it's not Broadway, but it's much more entertaining. And of course, what's the goal? To effectively communicate to the jurors. And I think this is good.
Yeah, I mean, you of course are going to lose the demeanor of the witness. If the witness in the original case, for instance, got a tear in his eye, you're not going to see that.
All the nonverbal is out.
The nonverbal
Right.
communication is out. But I think that from a minimum comprehension standpoint, this makes it really clear. They know who's speaking. They're not saying, wait a minute, was that a question or an answer? Because you read these transcripts and that's what it can turn into.
Yeah, no, I like it. I think it's a great tool and good for them for allowing that.
We are waiting for this trial to go back live again in Nevada. They are supposed to be starting any minute now, and while we wait for things to gear up in the courthouse, I'm going to go and listen to some of this testimony from yesterday late afternoon of a trauma surgeon who testified on behalf of the defense, but I think the surgeon did nothing to help the defense and ultimately wound up helping the prosecution. So we're not going to listen to the direct examination by the defense. We're going to listen to the cross-examination by the state, because I think that the testimony, again, clearly helped the state. I think it fell apart for the defense.
And again, you were talking about what you medically deem mutilation. Rage and anger versus a more controlled mutilation. Do you remember that?
Yes, sir. I know.
You're aware of the fact, aren't you, from having reviewed this, that there is a constellation of 5 separate collections of 8 stab wounds on this body?
Yes, sir, there are.
There is a collection of 5 stab wounds to the right side of the head. I'm sorry, 8 stab wounds to the right side of the head.
Yes, sir.
8 stab wounds to the front of the neck.
Yes, sir.
8 stab wounds to the back of the neck.
Yes.
8 stab wounds to the right breast.
Yes.
8 stab wounds to the left.
Yes.
Would you agree with me from reviewing those photographs that those seem to be a little bit more controlled as far as the placing of those versus some of the other injuries you've seen?
No, sir, I don't think I could.
All right, let me put it this way. Do they seem to be in a close area?
Yes, sir, they are.
All right. And maybe that's how I should word this differently, is that the individual inflicted those injuries in a, I would describe, a controlled area.
A small pattern, yes, sir.
Okay. For the 5 to the head, I mean the 8 to the head,
Yes,
the 8 to the neck,
yes, sir.
the 8 to the back of the neck,
Yes,
and 8 to the right chest,
yes,
8 to the left chest.
yes, sir.
And you have, I dare say, treated thousands of injuries.
Yes, sir.
Are we safe to say hundreds of stabbings?
Yes, sir, absolutely.
Would you agree with me that it's very rare in your experience to see this many groupings like this? Have you seen groupings like this before?
Yes, sir, I have. And what I will say is that in areas, in the patients that I've treated, that's actually not an uncommon occurrence, because we don't know what happened when we were there, but what happens often is they'll start stabbing, and then the victim moves. And so the next target is they can get as many stabs as while they're trying to control the victim and thrust in the knife. So that's been my experience and what I've seen.
And you've seen it where the exact same number in each area?
Well, not the exact same number, but what I'm saying is they'll stab as many times as they can until the patient moves.
Sure. And this is somewhat atypical in that it's 8 in each one of those 5 areas.
Yes, I don't know if that's significant or not.
Well, in the sense of your experience, you haven't seen where someone puts 6 in one spot of the body, 6 in another spot of the body, 6 in another spot of the body, 6 in another spot, and 6 in another spot.
I can't recall, no, sure of that.
And then going to the cause of death, Mr. Pitaro just read to you the doctor's testimony from what is page 20 in the transcripts, where it's read, the cause of death was multiple stab wounds of the neck, the chest, and the back.
Yes, sir.
So you would agree with me that the doctor's testimony is that injuries outside of the neck, the chest, and the back were not the cause of death?
Probably not.
Okay. Do you want to look at the testimony itself?
No, sir, it's not that. It's just that, if I may, typically what happens when somebody's stabbed multiple times like this without a major, an injury to the heart or a major vessel, it's one of two things. They either exsanguinate and bleed to death from the accumulation of injuries, or if there's injuries to the chest and there's injuries to the lungs, they suffocate because the lungs drop. So we don't know, but this could have been, she might have suffocated and still bled out from some of these other wounds. That's why the ambiguity to my answer.
Okay. And in her answer, when she testified, she said the other stab wounds penetrated into muscle, which caused hemorrhage, but did not penetrate into any vital organ. I think that's what you're describing, in essence.
Yes, sir.
And she goes on to say, for instance, all the stab wounds on the back of the neck and on the top of the head only penetrated the skin, did not go into the head. So those injuries to the head and the back of the neck aren't causing death.
Correct.
And then the injury to, let's say, the pelvis area that enters your vagina, that didn't cause death.
Agreed.
And that the injuries to her right hand, which are, have you heard of the concept of defensive wounds?
Oh, absolutely.
Would you agree with the doctor's assessment that the injury on the right hand and on the left arm were defensive wounds?
It's likely, yes, sir.
And those wounds did not cause her death.
Yes, sir.
So we have injuries to the back of the neck, the top of the head, to the right hand, to the left arm, and to the pelvis area going into the vagina, all that did not cause death.
Agreed.
And then you were asked questions about a serious wound and severe force. Remember those questions?
Yes, sir.
Would you agree with me that a wound could be generated in a non-severe fashion, but creates a severe wound?
Yes.
In the sense, and maybe I should say it this way, if I walk up with a knife to you and I stab you, I don't necessarily have to use a lot of force, because as you said earlier, if I don't hit a bone or anything like that, it'll relatively easily go into your body.
Yes, sir.
Or you doing it to me.
Correct.
But I could create a severe wound in your body if I know the best place to stab you.
Correct.
Or I just happen to stab you in a location, let's say like the liver, where it's going to cause problems for me to recuperate.
Correct.
So the amount of force that's necessary to inflict the injury doesn't make the injury non-severe.
Correct.
Rights and buttons. pass the witness, thank you.
All right. Mr. Ray?
Yeah.
So that's a trauma surgeon, rather, who testified on behalf of the defense, but that was cross-examination, and I think that he was more helpful to the state. The defense tried to get him to say that there was really nothing unusual about this murder, but bottom line is that there are these 5 different constellations, so to speak, of 8 stab wounds each, and the cross-examination there I thought was very skillful. Got him to admit, Michael, that there were 8 to the right side of the head, 8 to the front of the neck, 8 to the back of the neck, and then 8 on each of the 2 breasts, and that adds up to the 45. 5 different constellations of 8 stab wounds. And they're saying, look at the locations of the injuries. Look at the number of the stab wounds. This looks more like mutilation than just the average enraged murder. And the doc had to say, well, he starts to say it's uncommon for there to be multiple stab wounds of this nature, and then he tries to say, well, but when people are stabbing, they're just trying to kill someone in a fit of rage, and you see multiple stab wounds all the time, and then they had to get him to back up and say, but look at the numbering and the sequencing and the location. He's like, oh yeah, that is uncommon. I don't see that very much.
It blew up really on the defense. I mean, it gave them not just the opportunity for the prosecution to reinforce the mutilation nature of these wounds, but you've got a situation in which this witness walks in the door as a defense witness and walks out as a prosecution witness because the prosecution did such a great job on cross. I mean, at the very minimum, as a prosecutor, anybody cross-examining, you want to neutralize that witness. You feel good if you've done that. That's your job. If you can turn them and the jury thinks that person is on your side as the cross-examining party, when you're done, man, that's a home run.
Yeah, I haven't seen that very often
no,
in many of the cases we've
easy.
covered, but it happened right there. And oftentimes we sit here and say that, and I've made this criticism of several prosecutors of cases we've covered here, and I say, wait a minute, that was a horrible cross-examination. And some of the analysts sit in your chair, Michael, and say prosecutors aren't used to cross-examining people, so oftentimes they're not as good at it, because they don't do it as much. But in that case, I thought the cross-examination was drastically better than the one that we saw of the minister,
yes,
who could have been better cross-examined.
Yes, and just very effective. I mean, they could not have done it better, gotten more out of this guy.
Yeah, I agree. That was a good one. I know you need to hit the road, Michael, so Michel Bryant, attorney. Always
a pleasure,
former
Aaron.
Court TV expert extraordinaire. We will see you back here again sometime soon.
You bet.
We're going to continue to listen